When it comes to estate planning, two of the most common tools are wills and living trusts. While both help ensure your assets are distributed according to your wishes after you pass away, they operate very differently and serve distinct roles. Many people assume that having either a will or a living trust alone is sufficient, but understanding the unique features of each is crucial for effective estate planning. Choosing the right option, or using both together, depends on your personal goals, family situation, and the complexity of your estate. In this video, we'll explore the top 10 differences between a will and a living trust to help you make informed decisions about protecting your legacy. 1. Activation. When they take effect. One of the most fundamental differences between a will and a living trust is when they become active. A will only takes effect after your death. It serves as a set of instructions for the court during the probate process, telling the judge how to distribute your assets. In contrast, a living trust becomes active the moment you create and fund it. A living trust is a living document that you manage while you're alive and mentally competent. If you become incapacitated, your successor trustee can step in and manage your trust assets without court intervention, making a living trust a useful tool not only after death but also during life if needed. 2. Probate process. Avoidance or requirement. Another major difference is how each tool interacts with probate, the court-supervised process for settling an estate. A will must go through probate, meaning the court must validate it and oversee the distribution of assets, which can be costly and time-consuming. Probate can delay the transfer of assets for months or even years, depending on the complexity of the estate and court schedules. A living trust, however, avoids probate entirely for any assets held within it. Upon your death, your successor trustee can immediately begin managing and distributing the trust's assets according to your instructions without involving the court, making the process faster, more private, and generally less expensive. 3. Privacy. Public versus private documents. Privacy is a major consideration when planning your estate, and wills and living trusts offer very different levels of confidentiality. Wills become public record once they are filed with the court for probate. This means that anyone, including creditors, estranged family members, and even strangers, can access details about your assets, debts, and beneficiaries. A living trust, on the other hand, remains private. Since it does not go through the probate process, the terms of a living trust and the distribution of assets stay confidential. This privacy can be especially important for those who value discretion regarding their financial affairs. 4. Incapacity planning. Managing assets if you're alive but disabled. A will offers no assistance if you become incapacitated. If you cannot manage your financial affairs due to illness or injury, a court must appoint a conservator or guardian to oversee your assets, even if you have a will. This court process can be invasive, time-consuming, and costly. A living trust, by contrast, includes incapacity planning. You can name a successor trustee who can immediately step in and manage the trust's assets if you become unable to do so. This arrangement avoids the need for a court-appointed guardian, simplifies the management of your assets, and ensures that your financial affairs are handled according to your wishes without delay. 5. Asset coverage. What's included? A will governs only the assets that are owned in your name at the time of your death and do not have designated beneficiaries, like a home, personal possessions, or a bank account. It does not control assets with joint ownership rights or assets that pass automatically upon death, like retirement accounts or life insurance policies with named beneficiaries. A living trust, however, governs only the assets you transfer into it during your lifetime. If you fail to transfer an asset into the trust, that asset may still require probate unless you also have a pour-over will, directing it into the trust after death. Therefore, funding the trust properly is crucial to realizing its full benefits. 6. Cost. Upfront and long-term expenses. Setting up a will is typically far less expensive and simpler than creating a living trust. A basic will can be completed relatively quickly with the help of an attorney, often for a few $100s, whereas establishing a living trust can cost significantly more, sometimes thousands of dollars, because it involves more complex documentation and requires transferring assets into the trust. However, while a will's lower initial cost may seem appealing, the probate process that follows can be expensive and time-consuming for your heirs. A living trust, despite its higher upfront cost, can save your estate considerable money and time by avoiding probate after your death. 7. Court involvement. Supervision versus independence. Wills inherently involve the courts through the probate process. The court supervises the entire procedure, from validating the will to appointing executors to overseeing the distribution of assets. If disputes arise, they are resolved through court proceedings. Living trusts operate independently of the courts. The successor trustee administers the trust according to your instructions without court oversight. This minimizes legal entanglements, speeds up asset distribution, and reduces the possibility of court battles, although trusts are not immune to litigation if someone contests them. Overall, trusts provide a smoother, more autonomous method of estate management. 8. Ease of updating, modifications and flexibility. Both wills and living trusts can be modified or revoked during your lifetime, but the process differs slightly. A will is typically updated through a document called a codicil or by drafting an entirely new will, and changes can usually be made relatively easily. A revocable living trust offers even more flexibility. You can amend it at any time while you are alive and mentally competent by simply signing a trust amendment or, if changes are extensive, creating a restatement of trust. This flexibility ensures that as your life circumstances change, such as marriage, divorce, birth of children, or acquiring new assets, your estate plan can adapt accordingly. 9. Protection against challenges. Will contests versus trust disputes. Both wills and trusts can be challenged, but wills are statistically more likely to be contested. Since wills go through the probate process, it provides an open opportunity for disgruntled heirs or creditors to dispute the will's validity on grounds such as undue influence, lack of capacity, or improper execution. Trusts, being private and not automatically subjected to court review, tend to face fewer challenges. Additionally, living trusts often require more formal steps during their creation, such as funding and ongoing administration, making it harder for challengers to argue that the document was fraudulent or created under duress. 10. Handling minor children. Guardianship provisions. If you have minor children, a will allows you to name a guardian to take care of them if both parents pass away. This is one of the critical roles of a will, as the court usually honors your choice of guardian unless there is a compelling reason not to. A living trust, however, does not allow you to designate guardians for minor children. Trusts are primarily about managing and distributing assets, not making personal care decisions. Therefore, even if you have a living trust to manage your assets, you still need a will, specifically a pour-over will, to address guardianship for minor children. Both wills and living trusts are essential estate planning tools, but they serve different purposes and offer different benefits. A will is simpler and less expensive up front, but it requires court involvement and becomes public upon your death. A living trust is more complex and costly to set up but provides privacy, quicker distribution of assets, and protection in case of incapacity. In many cases, a comprehensive estate plan will include both a will and a living trust to ensure all bases are covered, including guardianship for minor children and smooth asset management. Understanding these top 10 differences empowers you to make better decisions about how to protect your assets, care for your loved ones, and create a lasting legacy.